Welcome to the season finale of the 2018 series of LOMAD TV. My name is James Cousins, and I'm coming to you live from the bridge of the Starship Enterprise, something that I've desperately wanted to do ever since Melissa bought this green screen. And I thought, what better way to kick out the end of the year by giving the case law update for 2018. So for the next hour, our mission will be to explore strange new case law, to seek out new defenses and new legal theories, and together we will boldly go where no law firm has gone before. Mr. Walker, on screen. Next slide. 2018 was a great year for case law. We had a lot of very interesting cases, and we had a lot of cases that revisited old topics, and we'll be going through them based on our selection of the things that we thought would be most interesting to all of you to hear. And of course, there are fun and crazy cultural references in all my slide titles, so I hope you enjoy those. The NAP case is an interesting claim. For a long time, everyone has treated Section 13A6 and the board's circulars about contacting doctors with a substantial amount of respect, to the point where a lot of law firms are even scared to discuss the purpose or the primary topic of a deposition with a doctor before the exam or the deposition starts to take place. In this instance, the IME doctor contacted claimant's law firm and asked what the topic of the deposition was, and claimant's law firm responded by text message. I find that a little odd that they had cell phone numbers, but nevertheless, they texted the doctor back and told him what the topic of the deposition was. That fact came out during the deposition, and the defense attorney in that case moved to preclude the doctor's report and testimony based on undue influence, a violation of Section 13A6 and board subject number 046-124. The board did do that. The board found that even though the text message was just to tell the doctor what the subject was, that because it wasn't copied to the opponents, the method of conversation being sort of hidden violated the purpose of the circular and the statute. The third department reversed, finding that it was an abuse of discretion for the board to preclude this evidence, that there was no evidence of undue influence because if you read the transcript of the doctor, there was no evidence that his testimony was substantially different from his report, and that telling the doctor why he was being deposed was a ministerial task, and it didn't reflect any effort to influence the doctor. So now we have a line drawn in the sand to tell us what we can and can't do. So we can definitely tell the doctors the purpose of their deposition or the topic of the deposition. Whether we can go any further has yet to be determined. Next slide, please. Section 20. We oftentimes like to use Section 20 because we prefer one judge over another. I mean, not all judges are created equal. But in this case, it's an interesting application of Section 20. I would have thought that if one judge heard all the trial testimony, was present for the testimony of the witnesses and the claimant, that Section 20 would apply and we would be entitled to a decision from that judge on the merits, absent some extraordinary circumstances. In Karam v. Rensselaer County, apparently the only fact that came up to the third department level was that the judge that heard the testimony was absent. And the third department said that the absence, without, I guess, any further explanation, was enough justification for the board to assign the writing of a reserved decision to a different judge who had not heard the testimony. The other thing that's really interesting about this case is that the underlying premise of this claim was it was a stress case brought by a member of the Rensselaer County Sheriff's Department who was an ethnic and racial minority. And the premise of the stress was that apparently his workplace was full of ethnic and racial banter back and forth between himself and his supervisor, who was Polish. And the board found that because the claimant was shown to have engaged in this back and forth banter, and oddly enough, the banter was between the claimant and his supervisor, and the claimant had the supervisor be best man in his wedding, but then he filed a workers' comp claim against him saying that he discriminated against him at work. The board found that because he engaged in this banter, that it clearly wasn't the type of stress to which others, or was sufficient to bring about the claimed conditions. And the third department was clear to say, although we find the disparaging statements and conduct described abhorrent and unbecoming of a public official, under the circumstances presented, they would defer to the board's credibility assessment. So they just had to get that in there, that they didn't condone anything that went on there. Next slide, please. So now we're into some 2017 reruns. These are cases that we talked about last year that came back, and this one came back because the leave to appeal to the Court of Appeals was denied. This was one of the attorney fee cases that we talked about last year. $65,000 attorney's fee was reduced to $30,000 based upon a review of the fee application. And I guess the judge below found that there was only $30,000 worth of work that could be justified. Claimant's counsel wanted $65,000 because the award that they got for the claimant, it was a death claim, was something northward of $500,000, closer to $600,000. This just came back for denial of review. The board's ability to reduce these fees, change these fees, modify these fees is largely going to be remaining undisturbed. And I thought it was notable here that the $35,000 reduction was apparently just enough money to warrant claimant's counsel trying to go to the Court of Appeals. And it turns out they threw money out, good money after bad. I also want to mention, it's not in the decision here, but we talked about it at length last year, the Mancini case, which is the claim where the third department found that the durational caps for PPD benefits apply to claimants who get emergency or extra benefits awarded under Section 15.3v. If you remember, that's the provision of the law that says if you collect a schedule of 50% or greater and you continue to show that injury and that injury alone is disabling you, and you take some other steps to engage in board retraining or vocational rehabilitation, you can get substantial additional benefits awarded under Section 15.3v. In this underlying claim of Mancini, the third department last year said the durational caps apply, so you have to do an LWEC analysis. Claimant's counsel was not satisfied with that answer, and they took it to the Court of Appeals. The Court of Appeals issued a decision about 2 weeks ago saying that they totally agreed with the third department, durational caps apply. It's not only consistent with the writing of the statute, it's consistent with the intent behind the statute, although it drew a really sort of strong dissent from a judge of the Court of Appeals who had written some other very important cases, Judge Wilson, who wrote the Terra Nova case that we talked about last year. So interesting, the court disagrees with itself there, but we do get the decision which we want, which is the application of the durational caps. Next slide, please. So this case came up because I was very surprised. I think it came up because the firm was really trying to fix an error here. Defense firm here failed to file a pre-hearing conference statement he failed to serve it on claimant's proper counsel. And that failure happened twice. So twice they filed it with the wrong claimant's attorney, and they tried to get this case overturned, or that ruling overturned on an appeal, which of course you know that if you fail to timely file a pre-hearing conference statement, most of your defenses are going to be waived except potentially causal relationship. And that's not waived because it's the claimant's burden in the first instance. So in the Love case, the third department says no mas, and leave to appeal to the Court of Appeals was denied. And we want to contrast this with the Portlet case, which you see below there. Portlet, the claimant essentially committed fraud in the inducement. The claim was so fraudulent, the claimant not only lied about how disabled she was, turns out she lied about how much she injured herself or whether she did in the first instance. The third department and board in Portlet found that it was appropriate to excuse an untimely filed C7 and an untimely filed pre-hearing conference statement because there was fraud in the inducement. The employer had no way of knowing that the claim was fraudulent until they obtained this evidence and obtained some additional evidence that showed that the claimant was lying about how disabled she was. Next slide, please. Oh my gosh, every year I get a stack of cases dropped on my desk that are claims brought in the Supreme Court and various courts around the state where third-party lawyers are trying to force carriers to cram down their liens, to take voluntary reductions, or to split liens against third-party recoveries a third. They love it. They love it because largely, and there's a large subset of cases where they can't get more money in the third-party case than was paid out in the comp claim because there's so many claimants out there with $100,000 policy limits. So the claimant's defense, the defense policy offers the $100,000 limit. They take it and they think, great, I'm going to get a $33,000 fee. And guess what? In none of these cases did claimant's third-party counsel ever bother to suggest that they take a lower fee. They just want their contingency fee because you know what? They're entitled to it. I'm being facetious if you can't tell. So they then go and ask the carrier, well, would you guys please take a hit? We know you paid out more money and the claimant's more injured than this, but this is the best we're going to get. We'd like to get them something, please. And in a whole bunch of cases, employers and carriers got tough and said, go climb a tree. Go climb a tree. We want our money back. Forget it. And then claimants' third-party lawyers, not knowing any better, file all kinds of motions that probably should be deemed frivolous because there's so much case law out there saying that they can't do what they're trying to do. And they did that in Batista. They tried it in Estevez. And then they tried it in Rahman. All three cases, they demanded that the carrier reduce their lien, and they asked the court to forcibly reduce the lien over the carrier's objection. And in fact, in one case, which is the Batista case, which is the lead file on this slide, they actually asked the court to impose penalties against the carrier for not agreeing to reduce their lien. All three cases, the court said, no way. We will set the lien for you, but only based upon the statutory reduction contained in Section 29. We are not going to reduce it further. We have no authority to do that because guess what? They don't. It's well-settled case law. So if there's any opportunity for someone to please teach this section of the law to the plaintiff's bar, I'd appreciate it because it would save us all reading cases every year. Next slide, please. So we always get questions about the finality of Section 32 settlement agreements. They come up a couple times a year. Our clients ask us if we're dealing with a pro se claimant, you have to tell them that this is final. I have certain colorful ways of explaining it to them that I can't really repeat here on television. But they're final. It's final. The law says that it's final. The only way that a 32 can be reopened is if all parties, so that means the employer, carrier, and the claimant, and the board agree that the 32 can be revisited. In this case, the claimant realized apparently after the fact that for some reason his average weekly wage was miscalculated in his underlying comp claim, and he tried to get the case reopened. When nobody would take any action, he hired an attorney and filed an Article 78 proceeding, which if the attorney had read Section 32, they might understand was a losing proposition. But they filed an Article 78. They go to Supreme Court in New York County, and the Supreme Court says, listen, we don't even have jurisdiction to consider this. This would have to go to the third department who has exclusive jurisdiction over rulings of the board. And by the way, we read the statute. Unless everyone agrees, we're not going to revisit this. You knowingly entered into that agreement. If you didn't catch that error beforehand, even if it is an error, it's not clear whether it was an error. But even if it was an error, tough. We're not revisiting it. So final means final. The 32 is over with and closed. Next slide, please. Always a bunch of good fraud cases. We picked this one because I thought it was interesting because this is the sort of fact pattern that gets presented to our office pretty frequently. But it's also a concern that I think lots of employers and carriers have because they're presented with an accident where the mechanism of injury just simply doesn't credibly lead to the type of injuries that the claimant is reporting. And there's something else usually smelly about the case. And in this case, what happened is the claimant is a bartender. She's standing on some kind of shelf and she alleges it collapsed underneath her. She fell to the ground. She lost consciousness. She's super injured. Well, guess what? It smells. It smells because the claimant had a surgery, a lumbar fusion, a month before this accident took place. And it turns out that the initial statements from the witnesses didn't indicate that the claimant actually even really stopped working. The shelf that she was standing on collapsed. She dropped to the ground a very short distance, and she just kept on working without indicating that she'd even hurt herself. The employer was able to produce video footage of this evidence, which apparently swayed the judge and the board to conclude that the claimant was simply exaggerating what was going on in this accident. She continued to work for her shift without any evidence of any condition or anything wrong with her. And guess what? She'd had a low back surgery a month before the accident. So it was reasonable for the board to conclude that she wasn't injured in the work accident. What a great defense. Kudos to the defense firm that defended this file. Next slide, please. IME is being precluded. This case, Dr. Ploss is an IME for the claimant. So the claimant has a treating doctor, but then goes to see Dr. Ploss to get an opinion on causation. And Dr. Ploss comes in, does a review, issues an opinion, but they don't do anything to make it comply with Section 137. They make it seem like he's going to treat with Dr. Ploss. Guess what? Dr. Ploss even testified, I wasn't reviewing this case or seeing this claimant to treat him. I don't treat this claimant. I was doing it to give him an opinion. There is a 2008 case from the Third Department, the Esterlons case, which is the lead decision in these line of cases, which says that if a claimant goes to seek an opinion on one of the primary issues in the case, let's say disability, causal relationship, etc., there's no evidence that the claimant sought to form a relationship with that doctor as a treating physician, e.g., let's say there's only one visit. The doctor may not have conducted an examination, only a record review. There were no subsequent visits. The doctor didn't offer any treatment. He didn't suggest any treatment, etc. If some of those facts are in place and you can prove that this IME, this treating doctor is in fact actually an IME, they can be struck under Section 137. There is no distinction in the law between an IME for the claimant and an IME for the carrier. And for a long time, claimants tried to hide their IMEs by suggesting that they were treating doctors. That's not true. Leave to appeal the Court of Appeals was denied in this case. It is well-settled law, so we don't think this is going anywhere further. Next slide. Oh, don't we all know that throughout the course of this year, and since the board had the regulations changed in connection with the 2017 amendments, the board has been very aggressive in denying appeals where they felt that the RB89 form was incomplete or incorrectly filled out. And we also know for a long time the board was updating the RB89 and RB89.1 forms like it seemed like every other day. It's probably not that quickly, but it seemed like fairly often and a couple times. They updated the form, and it really made no substantive changes. It just updated it. So in this case, claimant files an RB89, and this is one of those times where the board issued a new form and said, we want you to use the new form as of this date. Start using the new form. Well, 5 days after that deadline passes, claimant's counsel files an RB89 using the old form. The board, seeing their opening, denies review, says, you used the wrong form. We're not going to review this. Your appeal is denied. We're not reviewing it. Goodbye. They file full board. Full board says tough. They go to the Third Department, and the Third Department says that it was an abuse of discretion. It's a very rare finding. It was an abuse of the board's discretion because guess what? It was only 5 days after the effective date of the new form that this now defective or defunct or outdated form was filed. And when the appellate division reviewed the forms and compared them, they could find no substantive difference between the old form and the new form. So apparently, in their view, the board just issued a new form to just, I guess, change the way that it looked or the text or whatever, but it didn't change any of the substance. And notably, I love footnotes. I'm a comp geek. I love footnotes. There's a footnote in this case that's sort of like a knife at the heart of the board. So they found that it was significant that the Attorney General decided not to respond on behalf of the board. So an appeal was filed to the Third Department. It was perfected, and the Attorney General wrote to the Third Department and said that they would not be defending the board's decision. They would not be filing a brief. So Third Department found that significant, and it led to the decision here. Next slide. Now we have to compare that case with this one. There are different facts here. I don't think that this one really means anything with respect to the new ones. I had a fight with Melissa about this. She usually wins these fights, but since I'm the one on television, I think I'm going to win this. Let's see if I can convince you. So the Johnson case, 5 days using the wrong version of the form. Waffle, the carrier uses an RB89.2, so they use the full board review form, not the RB89. They use a full board review form to file for intermediate appeals. So they should have used the RB89, but they used the RB89.2. They figured out that it was wrong, oops, and they refiled using the correct form. However, their refiling was not timely. The board panel said, nope, not going to do it, sorry. This goes to the Third Department, and in this case, once again, great footnote, I'm a footnote geek. In this case, the Attorney General submits a brief and argues strongly that it was within the board's discretion to deny this untimely appeal and to find the initial appeal using the wholly incorrect form improper and denied on those grounds as well. So in this case, the Third Department affirms the board's activity. The footnote does refer to Johnson. The footnote in this case refers to Johnson and contrasts it. So I think this one's a little bit different. I don't know that this says anything about how these new rules are going to be applied, but you also know, we're not going to discuss it today, this is just case law, but you know that the board has issued a long manifesto describing how we're supposed to fill out each section of the RB 89 or the RB 89.1, what's acceptable, what's not, what can be done and what cannot be done. So they're trying to square this all away, but there's still a whole bunch of case law out there that's sitting talking about whether or not the board's use of discretion in denying review is proper. We do know from the General Counsel of Workers' Compensation Board that there is at least one more case sitting out there that goes directly to the board's really sort of aggressive use of the new regulations to deny appellate review, and we haven't seen that decision yet. We confirm that neither this nor Johnson were the decision. Next case, please. Well, every year I get another pile of cases on my desk where some poor person filed an appeal from the wrong decision. So we know that when you get a bad decision before the judge, we'll just talk about it in general terms. You file to the board panel, and let's just say the board panel gives you a bad decision too. Then you may do what I choose to do usually, which is just ignore the full board, because my chances of getting a reversal on that are slim to none. And I'm just going to go straight to the third department. I will perfect an appeal to the third department from the EBRB1, from the Memorandum of Board Panel Opinion. Some people elect to file to the full board and then apparently only file a notice of appeal from the full board's denial. This happens every year. If you appeal from the full board and not from the underlying panel decision, the third department is not going to reach the merits of the decision. They're just going to decide whether the full board denial was appropriate based upon what the board said in that decision. The standard of review is arbitrary and capricious or an abuse of discretion. You don't get the more heightened standards that you might get based upon what the underlying decision is. So in this case, Duncan v. Crucible Metals, the carrier doesn't even get to argue the merits of whether it's the liable party, because guess what? They didn't appeal from the right decision. They appealed from the full board denial, not from the underlying panel decision. Next slide. All right, I talked to you guys about this once before. I won a case before the third department. I'm just including it in here to show that I won a case before the third department. It's really hard. We got them reversed on the issue of whether the claimant's accident was actually an accident or an occupational disease. The claimant was trying to say it was an occupational disease because the underlying record demonstrated beyond a shadow of a doubt that the claimant failed to give timely notice to the employer. The only way the claimant was going to get an established claim was if it was an occupational disease, and therefore they could apply the more liberal timely filing and timely notice requirements afforded to occupational diseases. In this case, the third department agreed with our office and with the taxpayers of the town of Hamburg that this claimant obviously had an accident, that there was no way to call this an occupational disease, that there was no proper notice given, and that the claim should be disallowed. And guess what? Subsequent proceedings after the appellate division reversed and remitted, the board came back and issued a decision sua sponte without further development of the record, disallowing the claim, finding that there was no timely filing or timely notice of the claim, and that there was a lot of prejudice to the employer because he had all kinds of treatment and lost time and didn't even bother to tell the employer ever that it was work-related. He just filed a C3 like 7 months later. That was the employer's first real notice of the accident. So that's a good claim. Enjoyed that. Glad to have won that. Next slide, please. This is something that I talk about every year, and it comes to the third department every year in one form or another. Apportionment. Claimants, attorneys, claimants, and even some judges love to think that the only standard of apportionment that's applicable in workers' comp is if the claimant was symptomatic and disabled in a workers' compensation sense at the time of the accident. Wrong. That only applies if the pre-existing condition is not the subject of a work-related accident. If the pre-existing condition is a workers' comp claim, especially if it's a PPD, by the way, if you got prior permanency in the claim, then man, it should just be like, as a matter of law. But if the prior condition is the subject of a comp claim, the standard of whether apportionment should apply is if the medical evidence properly or competently establishes that the current disability or injury is in some way related to the prior one. All you got to do is get an opinion saying these medical conditions are related, that the apportionment should apply. You don't have to get a doctor to say that the claimant was symptomatic and disabled in a workers' compensation sense. That is not the correct standard. So don't let anyone fool you. We certainly won't be fooled here. Next case. Next case. This is one of the most important cases that came out of 2018 from the Third Department. If you've ever looked at the schedules for schedule losses of use awards as they're written in the statute, and as the board has them in the various tables that they've promulgated, you can't get a schedule loss of use for the shoulder. You can't get a schedule loss of use for the elbow. You can have an injury to your wrist that, depending on how the symptoms manifest, could result in a schedule loss of use of the hand or the arm, but you can't get a schedule loss of use for the wrist. The same is true for the knee. You might have an injury to your hip, but it's going to result in a schedule of the leg. You might have an injury to the knee, and it will result in a schedule of the leg. You may have an injury to your ankle, and depending on how the symptoms pan out, you may have a schedule of the foot or the leg. So, what happens if I have a claimant who has multiple claims with injuries to the same extremity, let's just say the arm, and in claim 1, he hurts his elbow and gets a 30% schedule. And a couple years later, he has claim 2, and he has an injury to his shoulder and gets a schedule for that injury. Well, both the schedules would have to be awarded for the arm, right? You can't award a schedule for the elbow, and you can't award a schedule for the shoulder. The question is, do we get to take credit for the schedules even though the injuries were to distinctly different joints, and the guidelines provide different criteria for assigning the percentages based on the motion loss of the various different joints? The answer is yes. Thank the Lord. The answer is yes. The Ganduso case is where the claimant has an ankle injury that was awarded a leg schedule. He then has a knee injury, and he gets a schedule for the leg from the knee. The carrier argues successfully below that because there's no distinction in the law between a leg and a leg, that is to say a knee leg and an ankle leg, that they're entitled to get credit for that prior schedule. This is the Scali v. Ravenna exception, but it's also, that's for when it's not related, but it's also the special case law that talks about apportioning schedules. You just basically get to take credit for the percentage that it was awarded in the prior case. And in this case, the carrier in Ganduso, or the New York City Department of Education, the self-insured employer in Ganduso, gets to take credit for the prior ankle schedule against the knee that they just got awarded on their file. Great result, great case. It should affect substantial savings across many claims for all of us. So looking forward to using this case as a great big bludgeon against many of those claimants that we all know have tons of schedule loss of use awards, and they tend to be repeat filers. Next claim. I've talked at length over the last couple of years, and I wrote some blog posts about calculating average weekly wages. This is an example of why the daily wage calculator and the multiple method of calculation is really ridiculous, and we should probably try and fix it. If we could fix it, we might not save a lot of money across all the claims, but we would bring a lot more common sense to the system. So section 14.3 says that if you cannot use a method of calculation less than a 200 multiple result, unless, now there's a case law exception, and that's the Kellish citation right there, which says that unless you can establish that the claimant was not fully available for all the employment that the claimant had to offer, or was otherwise not fully available for employment period. So there's a bunch of old cases out there that involve geriatric camp counselors who work a couple weeks a year. They would get $700 for a week's worth of work, and that was all they worked for the whole year. They were otherwise retired. Those cases, the employer and carrier were able to establish that the claimant was otherwise retired and wasn't looking for work for the other 50 weeks of the year. They were only working those 2 weeks by choice. Therefore, they were able to get a favorable calculation using section 14.4, which talks about how it has to reasonably reflect the claimant's actual earnings. This case, they weren't able to prove that. So a claimant only works for a couple of days of the year, makes $2,900, doesn't work for the rest of the year, is injured during that employment, and gets the benefit of a 200 multiple. So get this straight. The claimant basically worked 3 weeks of the year, made $2,900, but now gets an established comp claim with an average weekly wage of almost $710 a week and is collecting a PPD award or a PTD award or a TPD award that exceeds the actual earnings that the claimant made during the weeks that he worked. How ridiculous is that? The third department had to affirm here because the statute is it's just the way the statute's written. There's no reading of the statute that gets you an alternative result. And they said in their decision that they thought that this was a ridiculous result. But guess what? 14.3 is a legislative mandate. They have no way around it. So if somebody from the Business Council is listening, this would be a great issue to take up, because I think that the third department is actually crying for help here and saying you probably should try and fix this statute because it just didn't work out well here. Next slide. Oh my God. I'm constantly saying that what I think a chiropractor is saying in a case is garbage. I actually use a more colorful word usually. But in this case, it was great because it made it into the record, and I chose to talk to you about this case because I was entertained. A chiropractor whose name is Xerxes. I imagine somebody from the East Ottoman Empire attacking the Greeks when I hear that name. But I hear Dr. Xerxes provided pure pseudoscience speculation, which is what the orthopedist IME said about his opinion of causation. And it turns out that the claimant in this case was also trying to pull a fast one because he was trying to mislead the IME during the course of the examination. So pure pseudoscience doesn't work. And this is my sort of tongue-in-cheek analysis, but I've said this to clients actually in the last couple of weeks, that the neck bone's connected to the shoulder bone is not good science once you leave kindergarten. And it is shocking how many times chiropractors, orthopedists, really brilliant doctors just say, well, I think because their body parts are connected, there could be a referred condition. Well, that doesn't always work. Next slide. This is a horrible case. I suggest you don't read this case. We're going to talk about it really briefly just because there are some interesting facts to this claim. The claimant was a 14-year-old farm laborer who was being illegally employed. It wasn't even like he was working for his parents. I don't know if there's a familial relationship between the farm owners, like a cousin or a nephew or niece or whatever. But he's a 14-year-old farm worker who's killed working at the farm. The parents of this farm worker fought tooth and nail to have the board find that the employer, the farm, was uninsured on the date of accident so that they could elect remedies under Section 11 and sue them in tort, which I think probably would have gotten them a gigantic award, certainly much greater than the no dependency death benefit, which in this case was doubled because of the illegal employment finding of $100,000. The employer, not knowing any better, I don't know why they would do this, actually fought a finding of employment. And they fought, I don't know why you would do that, because if the claimant's not an employee and he falls outside the statute, you're going to get sued in tort. Oh my Lord, why would you choose that? Your comp coverage is at least going to protect you and limit the damages. And in this case, the way that the parents fought the coverage issue was they did a lot of really detailed discovery and found out that when the policy was issued, the farm was, I believe, a PLLC with a certain number of members. And during the pendency of the policy, a whole bunch of corporate structural and ownership changes took place. They tried to argue that those structure and ownership changes voided the policy of coverage. And the important legal finding that we take out of this case is that the structural composition or the name of a company is not determinative about coverage. What's determinative is that the intent to cover and the risk insured against were controlling, and that the intent to cover and the risk against which was being insured was the same when the policy was issued as it was after all these changes took place. So unfortunately for these grieving parents, they were not able to sue the bejesus out of this negligent farm that didn't know any better and was actually taking steps to make itself liable for this lawsuit. Next slide. This case was selected, the Park case was selected because this is a common fact pattern. Although it was really ridiculous. This claimant has fibromyalgia. I don't even really know what that is. I don't think a lot of doctors know what that is. It's just people are having pain that they can't really figure out where it's coming from. My parents told me what that was when I was growing up, but we have a diagnosis for it in comp. The Park case, the claimant has fibromyalgia pre-existing and is somehow exposed to pepper spray in the course of her employment, and a couple of her doctors suggested it could be possibly, sort of, might be likely that the exposure to pepper spray could have flared her condition. There was a lot of testimony taken in this case, 5 physicians. None of them could say anything better than a possibility. That is a sort of fact pattern that comes out of solid defenses of medical cases all the time, and that's why it's instructive here. It's going to be another good case to cite going forward, where we can say, hey, if possibility isn't good enough in this case, it's not good enough in our case. Leave to appeal to the Court of Appeals was denied. Next slide, please. Oh my gosh. So I don't know if this is true or not. I'm not a doctor, but in this case, there was all sorts of litigation about whether the claimant had ulnar neuritis and cubital tunnel syndrome. So apparently no one in this litigation realized until they were ready to go to the third department that potentially ulnar neuritis and cubital tunnel syndrome are one and the same. And they asked the third department to take judicial notice of it. The third department said the same thing I just said. Oh my gosh, we're not doctors. We can't use judicial notice to find that out. You're going to have to develop that record to see if it's true, but we're not going to touch it. So I guess maybe that's the sort of research you should do. I know we're constantly doing medical research however we can, and trying to reach out to experts that aren't involved in our case at the current time to find out whether our theories about causation are accurate or not. Next slide. This case frightens me, the Knott case. I know the text is small and it's hard to read. The claimant had some kind of allegedly work-related condition and underwent surgery, and then long after the fact submitted a really garbagey medical report trying to get a claim established. After development of the record couldn't really take place because the claimant wasn't really cooperating, a lot of garbage was taking place in the claim too, the judge disallows the claim. The third department affirms the board's decision to disallow this claim, but they note, I think they might have misinterpreted it, the board's ruling as impermanent. So the third department says, we do not read the board's decision to disallow the claim based on the record as it existed as precluding claimant from submitting further medical evidence of a causal relationship between her injuries and employment. I'm not sure how to read this. I'm not sure what result this has. I don't know the exact decision in the reserve decision below or what the panel said in its opinion that really led the third department to believe this, except to say maybe somebody did say as the record then existed. But I've always operated under the supposition that if you elect to take a case to a decision, you got to live with it. So if your record's not complete, there's plenty of case law out there saying that a claimant can simply ask for NFA failure to prosecute when they're not ready to proceed because they think their medical is insufficient. It happens all the time. Good claimants lawyers who have good control over their clients have this happen when they think that they're going to lose their case on a medical issue because they want to get clarifying medical. I have this going on right now with a really good claimants lawyer. He's stalling to get better medical evidence because he knows that he might lose this case if it goes to a decision. And then that would be a permanent disallowance, despite what the third department might suggest here. Next slide. Great case, Turner. This is a sort of common fact pattern. We have an established claim. We have sort of the claim dying out and not seeming to have much going on. Then the claimant has a motor vehicle accident that's unrelated, and all of a sudden the claimant needs surgery, but claims desperately that the motor vehicle accident had nothing to do with it. Defense counsel in this case did a great job because they got the judge below to order the claimant to produce all of the documents relating to the lawsuit from the motor vehicle accident because they thought, rightly, that if the claimant had a valuable motor vehicle accident, those pleadings and bills of particulars and all the evidence in that case would talk at length about how seriously injured the claimant was in that MVA. And it would prove that the claimant was talking out of both sides of her mouth. She was not injured in the MVA when she's talking to the comp board, but she's super injured in the MVA when she's talking to the jury in the liability action. Well, the claimant never produced that proof, and the board took a negative inference. They said, you didn't produce that proof, and we don't think you're particularly credible otherwise, so we're going to draw a negative inference, and we're going to say that the surgery can't be related to your comp case because guess what? You didn't produce those proofs. Good practice point for defending claims. If you think the claimant has documents to which you don't have access to, get the judge to order the claimant to produce them. Don't let the judge order you to produce them. How often do we see in case law decisions weird orders for employers and carriers to produce documents that how could they possibly have easy access to them? Like the medical records from the MVA. It's not the employer's job to produce those. The claimant probably hasn't been directed to produce a HIPAA yet. Make the claimant produce those proofs. We should be allowed to make allegations about what could or could not be in there. Let the claimant rebut that by producing the documents. So, good litigation here. Very exciting. Good stuff. Next slide. Oh my lord. I tried to make this title entirely alliterative, but I couldn't. I came very close though, so I hope you enjoyed that. This is a great case. Once in a while, you'll hear a defense counsel say, "Well, this judge just didn't understand." There's maybe a common belief among the traditional lay American population that judges have some sort of like special ability, special knowledge. They're a cut above the rest. This proves otherwise. So we have an ALJ for the State Office of Temporary Disability who's walking into an elevator and claims that she was squished like a jelly donut between the closing doors. In all fairness, if any of you have been to the Workers' Compensation Board at the Ellicott Square building, those doors probably would squish you like a jelly donut. They wouldn't stop. But this is in New York City, and there was a camera inside the elevator car, and the camera proves that when the claimant was walking in, she brushed by the door as it closed. It didn't strike her, and she turned around and then began playing on her phone and didn't indicate anything. She didn't even rub where she brushed herself on the door. But she later decided to file a workers' compensation claim. I mean, this went right off the rails. She files a comp claim alleging that she was smushed between these doors and that everything is wrong with her. She was basically claiming ANCR whole body. The employer produced the video footage. They produced it to the court. They raised fraud. And, wow. So they got it. I mean, they didn't get a finding of fraud. But they used that to translate into a disallowance of the claim. There was no possible way that she was squeezed like a jelly donut. There's no possible way that her injury occurred the way it did. And it's not possible, just based on common sense, that she's as injured as she claims to be. My note to Benny here is that she had been on the bench for 10 years and then was terminated for filing this claim and pursuing a fraudulent claim. And the decision of the board and the third department basically do everything but say that the claimant here perjured herself. They don't come out and say that, but they suggest it very strongly. And then it turns out that the claimant is now suing the state to get her job back. My notation here is simply, oh my God. Next slide, please. Every year I talk about a case where the board makes a positive finding about the causal relationship of disability. That is to say, if a claimant's payments are payable on this file, usually it's in the context of whether the claimant's reduced earnings are causally related to the disability. This is a determination that the claimant's causally related earnings are not due to the claim where the claimant wants them paid, because the claimant wants them paid on one case where the average weekly wage and the rate is higher, but all of his disability is actually due to this other case where he has a much lower average weekly wage. This is the USWES case, or however it's pronounced. I'm not good at this. But good claim on causal relationship of lost time. I bring one up every year. I just thought I'd talk about it again. Next claim. Oh no. When I saw this decision come out, my heart sank. The 2017 amendments to Section 15.3W basically say that if a claimant is classified with a PPD and is found entitled to benefits at that time, they don't have to subsequently show attachment to the labor market. There was some lack of clarity, and I think there still is in my opinion, as to whether or not the statute as it's written can be given retroactive effect. That is to say, all those claimants that came before, even those 20 years ago before American Axle was even really good law or was used the way it is now, before labor market attachment became the big defense it is, those people, if they were found entitled to benefits at the time of classification, can't raise labor market. The board wants this statutory amendment applied retroactively to every case in existence ever that's still active at least. Now, the O'Donnell case, this was the first case up to the third department. The third department says, we find that it has retroactive effect, and they largely base this on the letter that the General Counsel from the Workers' Compensation Board wrote in support of the legislation and explaining the legislation, wherein he explains that it will apply to all claims. Now, that the General Counsel for the board says that, I don't necessarily think is going to be legislative history, and I think that the statute as written could be read to have no retroactive effect, because if you read all the case law that came talking about the changes to 15.8 and what needs to be in a workers' comp statute to give it retroactive effect, I don't think it meets those criteria. Maybe the Court of Appeals thinks so too, because leave to appeal was granted on October 18th. So we could be getting a decision on this case, depending on the methodology that was used to perfect it, whether they're going to allow it to go through the expedited decisional process or they want it placed on the regular calendar for the Court of Appeals. We may be getting a decision about this case fairly soon. Next slide. This is a premium audit case. This is for a retrospective premium policy. The only reason I included it is because it has a lot of import about the New York State Transportation Fair Play Industry Act and load brokers. Lots of you probably have load brokers that you're insured or that you TPA for. The New York State Transportation Fair Play Industry Act basically says that in the trucking industry, absent really, really exceptional circumstances, there's no such thing as a subcontractor. There's no such thing as a separate vendor. So if you're doing any sort of contractual work, if you're load brokering loads from A to B, be prepared to pay coverage for B. And in this case, State Insurance Fund did a premium audit of a load broker and said that they were going to charge them premiums for payroll based on their accounts receivable and accounts payable for their subcontractors as though they were wages. Big, big premium hike. They're basically insuring their own subcontractors through their own policy. But you know what? Section 56 now has made it pretty clear that a load broker is going to be responsible for injuries that occur to an uninsured subcontractor. And a lot of those subcontractors, guess what? They're uninsured. They're solo truckers. They don't carry their own insurance because they don't have to, because they're owner-operators. And when they get hurt, they are going to file claims, and they're going to look for somebody else to pay for it because they don't have the money to pay for it. So State Insurance Fund leads the way once again. Not a comp case, but it's definitely instructive to the practice. Next case. Melissa told me that this reference was really oblique in history. That's okay. King Charles I unsuccessfully argued jurisdiction when he had his head chopped off by Oliver Cromwell. McRae, this is a case. This is a case where a claimant is working for a railway company and happens to be injured in New York, but doesn't live in New York, and there's really no other connection to New York. And guess what? She works for an interstate railway. So she has a federal remedy that preempts workers' compensation law in New York. The board loves to find jurisdiction over whatever it can. You have a contact with New York State, they'll find jurisdiction. You got to be very careful about this. But in this case, and what's interesting is that the board has a lot of old cases that talk about whether and when the presence of a federal remedy precludes the board from finding jurisdiction. And in this case, what the Third Department appears to say in McRae is that the board's case law was wrong. Well, in this case, they first say the board was wrong about who employed the claimant, first thing. That was an interstate railway. Two, they say the board was wrong to find that because the claimant hadn't filed a claim using the federal system that had available to her, she could elect a remedy under New York workers' comp. Wrong. They found that Section 113, which is abundantly clear, says that the only way that a claim that is otherwise preempted by a federal remedy could be brought in New York is if all the parties consent explicitly to giving the board jurisdiction. My note on this case, which is longer than the discussion, is that there's a lot of case law by the board that suggests that if a claimant files for a federal remedy and can't get it, so let's say it's denied for one reason or another, upon the denial, they could then go back to New York and file a claim in New York alleging that Section 113 didn't apply because there was no longer a remedy that was exclusive or preempted New York. The McRae decision, depending on how you read it, might overrule all of that case law. It just says the federal remedy preempts the state one, and the only way that you get into a New York court and a New York board gets jurisdiction is if everybody consents. And I guarantee you that in a lot of these cases, the federal remedy is not going to provide the same kind of cost or outlay to the employer as the New York state one is going to, and very few people are going to consent to it. I also included this because we had a really interesting case that involved a doctor who worked for various hospitals, one of whom was the VA, and there was an allegation factually and in the medical record that part of the claimant's injury could have been due to his employment activities at the VA. And we did argue preemption. We argued that the board couldn't obtain jurisdiction over the VA and that the claim in New York couldn't be filed. Now, the board and the board ultimately got around that by saying that the claimant simply failed to prove his case on a medical basis. So the jurisdiction issue wasn't reached. The judge below actually found jurisdiction over the New York civilian employers, found causation, but tried to skip over the VA and didn't provide a really great explanation of how he could or should skip over the VA. And the board just simply said no, the case wasn't proven. So yeah, really interesting, and it comes up more often than you'd think. Next slide, please. This was one of the most important decisions this year. It was one of the most important decisions last year. Last year there were two decisions issued, the Wolfo case and the Burgos case. Burgos was a case where the board found that despite the claimant having less than sedentary work capacity, the claimant was properly classified with a permanent partial and not a permanent total disability. Shortly thereafter, the third department issued another ruling in the Wolfo case where they found that almost alone, the fact that the claimant had a less than sedentary work capacity was akin and equal to a permanent total disability because it met the standard of the claimant not being able to perform any sort of gainful employment. The third department had an argument with itself. It was almost like a personality split. One decision says yes, one decision says no, one says PPD, one says PTD, and the Wolfo decision got taken up to the Court of Appeals. And in one of the most important decisions of the year, which is literally only 2 sentences long, they reversed the Wolfo decision and said that the board's decision below, classifying this claimant with a permanent partial disability, was supported by substantial evidence. Almost no analysis. It was basically saying, guys, you can't have an argument with yourself. You can't create a conflict of departments among yourselves. You have to be internally consistent. The board, much to its credit, also fixed this problem. They removed the less than sedentary certification from the C4.3. You shouldn't see that unless an FCE is conducted and it goes out of its way to find less than sedentary work capacity. So much kudos to the board here to avoid a lot of nonsense. Next case. Again, one of the most important decisions of the year. This was a board panel decision that found that the medical treatment guidelines could apply out of state, applying the Kagan case, which is a really important third department and Court of Appeals claim about the board's right to promulgate guidelines, as well as the regulations. It turns out that when you read Kagan and you read the regulations, there is nothing in there that geographically limits the scope or intent or purpose of the medical treatment guidelines. The board finally decided that they'd had enough, that these out-of-state doctors were either going to comply with the guidelines. You shouldn't get to move to South Carolina and pop opioids like it's candy, but the guy who still lives in Batavia can't even take over-the-counter, like naproxen because the carrier's IME says that it's not appropriate, right? How is that fair? What is the rational distinction between somebody living in New Hampshire versus somebody living in New York? The distinction isn't their geography, and in fact, there is no distinction. The treatment guidelines apply to them, and in fact, the underlying decision from the board panel says that they would actually prefer the doctors use the forms, but if the forms aren't used, they warn carriers not to simply deny treatment because the proper form wasn't used. But guess what? The treatment guidelines apply. So this Nevada claimant who was trying to get all kinds of treatment that his analog in Poughkeepsie was trying to get and having it denied on MTG grounds, he doesn't get them either. His doctor has to follow the MTGs. Next case. So this, I picked this case because there's two fun things. First, the state insurance fund has gone after Dr. Grant with a vengeance. And a lot of Wendy Correctional Facility cases out there where he's trying to give 150% scheduled losses of use. Well, guess what? He finally made it to the big time. He made it to the third department, and the third department agreed with the board that Dr. Grant's reading of the guidelines was simply illogical. Well, now they fixed the guidelines, so now we're going to have to figure out how Dr. Grant's going to try and manipulate them going forward and how we can beat him up for doing that again. However, what makes this case really interesting is that for a long time, the board was issuing expedited hearing notices for weird things that were not controverted cases, like expedited hearing notices to resolve things like MG2s. Well, the board found here that they were going to be able to take some negative steps. You know, like they were going to preclude issues on failure to file PH 16.2 because they directed a PH 16.2 on the issue of permanency. What? Who does that? 300.38 doesn't apply to anything but C7 claims. If you're going to controvert the claim for benefits, then you get 300.38. Otherwise, you don't. The board actually self-corrected below, but the third department affirmed that that self-correction was appropriate here. So if you get an expedited hearing notice for something that doesn't seem right, you should probably call your attorneys to figure out what they should or shouldn't be doing or how you should be defending the claim or not. Next slide, please. This is the nightmare. This case is a nightmare. Board's general counsel disagrees with this. I disagree with this. Every defense attorney disagrees with this. Every self-insured employer should disagree with this. Hopefully the business counsel disagrees with this. So if somebody had schedule and non-schedule injuries mixed in the same claim, they could only collect the schedule if there was a finding of no further cause-related disability or need for treatment for the non-scheduled disability. There's tons of panel case law on this. There's tons of appellate division decisions affirming panel case law on this point, right? For some reason in Tahar, the third department decided that they were going to look at this outside the box. And they were going to decide that they didn't think that the operative issue was the classification, which is a legal finding, right? Non-schedule versus schedule. But whether the claimant was going to be entitled to collect an award for the type of classification which was provided to him. So they said, this is entirely consistent with all of our other decisions. We don't let you collect a schedule on top of a PPD. Well, that's wrong because you can. There's tons of case law about that. But if the claimant has a PPD, non-scheduled disability, but they're not out of work and they're not eligible for a PPD award, but they also have the schedulable injury, they could take the schedule. Using classification as a shield to a giant schedule loss of use is a common defense, probably for all of us. Everyone out there probably has had a claim at some point that was a neck and a shoulder, and the shoulder ended up being like a 70% schedule, and the neck was an 11.12A, right? It just barely met classifiable standards, but nevertheless, the claimant was classified even though they'd returned to work full duty. It happens, right? Now the third department is saying that claimant could go back and collect that giant schedule. The board vehemently disagrees with this and is actually saying that in decisional law that they think the appellate division is wrong, and leave to appeal and re-argue has been filed. I'm not sure of the status of that, but we're going to try and get an update. The board has actually said in Tubin v. Finger Lakes DDSO, which is another third department decision, in their case, Trevi Nail Corp., which was issued November 15, that they think that the appellate division is internally inconsistent, that they've misread the regulations that promulgated the permanency guidelines, that the appellate division essentially misunderstood the purpose of assigning permanency, and they're actually denying elections of claimants trying to go back and get schedules when they have a PPD. So the board is right now taking steps to overturn the third department, and they're using current decisional law from the third department that conflicts with the third department's own opinion to essentially ignore the operative effect of the Tahar case. So God bless them. Anything, if they ever need help from me, I'll step in and do whatever they want to help them defend that claim, because this case needs to be overturned. It's going to be very expensive. It is going to be a waterfall of old closed PPDs that were NCLT. Claimants are going to go reopen them and try and get schedules. Don't tell me that Alex Dell isn't going to try and do this. Try and get all these schedules awarded. Next slide, please. Well, we're just about over time. Next slide, please. This case was only funny because it was about somebody's live-in maid being hurt in their home in the Hamptons. Next slide, please. This was just an interesting case about whether or not what you say on the record about what stipulation means could be bound on you later on, which guess what, it can. So that's the end of our review of 2018's decisions. It is the 28th, so I guess, we're pretty close to the end of the year. I don't foresee any more appellate division decisions coming out because their yesterday was their last Thursday of the year. Next month or week's decisions, if any are issued, are going to be 2019 decisions. We may get some odd cases here and there, maybe a really probative panel decision or something from another department. But I guess without further ado, we can open it up for questions.
Dens M says, Section 32 of indemnity only inclusive of a PPD finding for multiple established injuries. Now 4 years later has additional schedulables, body site, or condition establishment. Is the claimant entitled to SLU for the new injury?
Well, the traditional language for the Section 32 indemnity only close out indemnity for the injuries, whether directly or consequential, and whether they're part of the case at that time or not. I mean, the claimant's closure is a closure. To obtain a further indemnity award, the claimant would have to seek to reopen and make an application for indemnity benefits. I think Section 32 would bar that, and I would argue that vociferously. Any other questions? Well, hearing no more questions and being over time, I want to thank you. I know it's a dry topic. I try and make it fun. I try and kibitz about it. I try and make it interesting and pick cases that are both instructive and entertaining. We are going to be starting our season 2, which will be Lawyers and Friends, which will be every month going forward in 2019. And on behalf of the law offices of Melissa Day, our staff, and our attorneys, I want to wish you a very happy new year. Make it so.
Because Zakari has a quick question.
Oh, okay.
I'm waiting for her to type it out.
Stand by. We're receiving a distress signal. I'm sorry. I'm geeking out, guys.
Leah Zakari says, what is the takeaway for Karam? K-A-R-A-M.
K-A-R-A-M. The takeaway from Karam is, I think that the board can basically say that a judge isn't available and switch it from one judge to the other. They've been doing it a lot in Buffalo. They were assigning RDs because they have judge problems. They're having a hard time getting judges. They've got a lot of judges that are retiring, and they're having a hard time with workload. So they're having judges, there are a handful of Buffalo judges covering Manhattan files. Well, you know what? I'll tell you what. If they're picking up a Manhattan file after some testimony's already been taken, I can guarantee you that they're going to make that Buffalo judge write the reserve decision on that case, because the whole premise of it is they got workflow problems. So basically, this is gutting Section 20. Absent some really extraordinary circumstances, and absent the board making no effort to explain what's going on, they're going to get to put whoever they want on the case. Could be good or bad. Any more questions? All right. We're breaking orbit for the year. We'll see you next year, everybody.